নিহিলাশা সীমার মাঝে অসীম দূরে। সেন্ট জেভিয়ার্স।
Good morning to one and all participating in this webinar on cybercrime and law organized by the Department of Information Technology and the Law under the Department of Commerce in collaboration with the Department of Computer Science. Amongst us, we have Reverend Dr. Dominic Savio, Principal, St. Xavier's College, Kolkata, Reverend Father Joseph Pulandai, Vice Principal, Department of Commerce, Morning, Reverend Father Peter Arokiam, Vice Principal, Department of Commerce, Evening, MCOM and Business Management Studies, Professor Bertram De Silva, Vice Principal, Department of Arts and Science, Reverend Father Johnson Pariara, Vice Principal of Raghopur Campus, Dr. Charlotte Simpson Vegas, Vice Principal, Department of Education, distinguished speakers of this session, Mr. Bibhash Chatterjee and Dr. Anirban Mojumdar, deans, professors, and dear students. The cyber world is expanding very rapidly, and so the cyber crimes. In this backdrop, the importance and scope of cyber law is increasing as we become more and more dependent on the internet and related technologies for our day-to-day functioning in the society. Now, may I invite and request Father Principal to deliver the welcome address.
Thank you, Professor Rinita. A very good morning to all of you. Today, we all have gathered here to make ourselves better aware of the most critical issues of working in online mode, that is cybercrime and the law. Cybercrime is a complex and the ever-changing phenomena. It has been increasing in complexity as the cyber criminals are becoming more sophisticated and are targeting consumers as well as public and private organizations. The world has become a global village due to network connectivity. But unfortunately, the reality of global connectivity is considered as a central element to contemporary cybercrime and perhaps give rise to many other multifaceted cybercrimes of tomorrow. The emergence of cyberspace creates a new phenomena that are notably distinct from the mere existence of computer systems themselves and the direct opportunities for crime that computers present. Within cyberspace, persons may show differences between the conforming legal and non-conforming illegal behavior as compared with their behavior in the physical world. Persons may commit crimes in cyberspace and use the information from the same commit such crimes. The identity, flexibility, disassociative anonymity, and the lack of deterrence factors may provide incentives for criminal behavior in cyberspace. Use of fake websites, marketing strategies, selling narcotics or weapons online, intellectual properties, software privacy, copyright infringement, trademark violations, theft of computer code, hacking emails, password, sending unwanted message to others, ruining a person's reputation, manipulating of records, altering websites, deleting web pages, uploading new pages, and even getting information to properly plan and commit illegal and unlawful acts. Mobile phone is a remarkable invention which promotes friendly human interaction almost everywhere. But it also serves as a facilitator of crime. It is widely known that both the common criminals and economic offenders across the world misuse the cell phone for perpetrating crime and hiding proceeds therefrom. Therefore, we can rightly say that this technological breakthrough is thus both a blessing and a curse. Cybercrime is a threat to individual, organization, as well as government. It has no boundaries. As cybercrime is committed online and also not specifically connected to any geographical area, A coordinated global response to the cybercrime problem is therefore needed. This is partly due to the fact there are a variety of concerns that hinder the efficient reduction of a cybercrime. To emphasize on cybercrime and prevention, this particular talk has been arranged for a larger audience that includes students, faculty, and anyone who works in the cyber world. Today's talk is intended to create an understanding about the cybercrime issues and the legal dimension. Today, we all assembled here to enrich ourselves, our knowledge, and to interact with the two eminent speakers, one from the field of practice and one from the academics. Today, we have with us Mr. Biva Chatterjee, Special Public Prosecutor, Kolkata Police, who will enlighten us on recovering digital data as evidence, prospects, and challenges. As the speaker for the second session, we will have with us Dr. Anirban Majumdar, Associate Professor, WBN JUS, who will give us an overview on the law relating to cybercrime in India. I extend a very warm welcome to the speakers, and also I would like to thank Father Joseph for taking the great initiative to organize these talks, and both computer science departments, head of the department, Dr. Romit Bede, and you have the commerce department, the law department. We have the head of the department, Renita Das. Then you have Dr. Madhu Agnigotri, and all the faculty members of the law of the Department of Commerce. I wish and hope that today's session will prove to be very useful in understanding the possible cyber crimes and the related law in this regard. And I wish you all the best. Have enriching sessions. Thank you very much.
Thank you, Father. With your kind permission, we continue this web talk. Today, we are honored to have with us Mr. Bibhash Chatterjee. He is a public prosecutor of cyber law and electronic evidence-related cases for the entire state of West Bengal. He is the author of several books and manuals, which includes Electronic Evidence, Cyber Security and the Law, and Cyber Contract. He is a visiting faculty of Cyber PS Kolkata, CIT, DSCI, Judicial Academy, West Bengal. He is a legal advisor on cyber crime related cases for CID, West Bengal. We are truly privileged and honored to have you with us, sir, and I hand over the session to you.
Thank you. Now, welcoming everyone who are present today to hear this talk is a very important subject nowadays, because we all are thinking about the inroads made by the virtual world in our day-to-day life, and we can feel the importance of the virtual world in this COVID era, because now people are more relying on contactless world, on the virtual world and all. Every day we are approaching, we are dealing with, we are making transactions every time. And India is a country where the youth populations, the average age, as noted in different resources available, the average age of Indian is 29. So if that been so, from that perspective, we have very young generations in India, and it is seen that major portions of the youth or young generations are all the time logged into either into the virtual world in different ways. They are either logged into through WhatsApp, Facebook, Twitter, and all these different gadgets. There are thousands of instant messengers in the world which can be used for different purposes, generally to send or share messages, different type of messages. Nowadays, the present cyber forensic is getting very complicated with the advent of the Mac and other who are actually using of solid state devices. And obviously, another huge challenge has been posed by the very repeated use of videos and other, because nowadays everyone is having a smartphone, and using that smartphone they are taking out or capturing videos, screenshot and others. So these are very huge data consuming files, and in many cases in extraction or recovery of digital evidences, these are giving a very challenging situations, creating a challenging situations in the world for the investigating agencies, for the law enforcement agencies, for the judiciaries, different stakeholders of the judicial systems, the forensic experts, and everyone. Now, what are the core topics, or what are the core concepts which I have understood working in this field, because I'm coming from a very practical field. Most of the theories are every day being tested in judicial forum when evidence is being placed, when an evidence is being placed before the court of law. So the basic concept which I understood being a little bit of technological, though we are every day we are learning, we are a student of law as well as technology. So new things are coming up every day, and new thinking are to be there how to how to come with those type of evidences in the different forum, because we, at the end of the day, if you want to prove something, we need evidence or facts which have to be proved. Now, from that perspective, electronic evidence, the basic two very important thing is that you see, whenever something is been, say for example, I have this mobile phone, and now there is something, some incident is being happening, and what I pick up this mobile phone and start making a record of the entire scene. So actually, basically, if we think that way, from the very strict programmer's concept, or a coder concept, or a technological concept, nothing is original in this virtual world, because when we are making a copy and saving the file into our devices, actually we are making a replica of the same. So taking a very simple example, some programmer is writing a code in a higher level language, basically, say for example in English and other, and in a particular language, say for which computer can understand, say Python, Java, JavaScript, whatever language he prefers. So in doing so, he is writing the program in a readable language like English and others, and the machine is then interpreting or compiling the same into interpreting the same into the machine understandable language. It is 0 and 1. So machine thereafter executing the job on the inputs and giving an output. So in this entire processing period, which the processor of a very computer is being doing for long, and this processing job is nothing but actually the machine only understands 0, 1 and execute the job as per the instructions or the statement of the program, and thereafter giving an output. So when we are writing something, that is actually converted into machine level language, and machine level language is converting the same into thereafter, after completion of the job and execution of the job, is giving a human readable output. So you see, nothing is original from the start to the end. But basically, if we now come to our latest landmark judgment by Honorable Supreme Court of India in Arjun Pandit Rao judgment, there is a little bit of steps been taken up to somehow manage out the situations. And this situation was started not in 2020 or 21. It was this a process, hard process of interpretations of electronic evidence that starts from Singh versus Cornell Singh, from Malkhan 1976, 80s and other. And in the very developed countries where we have seen a huge development in this virtual world, say US and other, they have seen earlier. So these different type, law is nothing but the interpretations of the law. So technology is coming up. Technology is been used in a very huge ways. There is we have no control on the development on, because when the new technology is coming in the world, there is always a corporate policy to maximize the profit. And thereafter, when this technology has been adopted, there are a lot of ins and outs. There's a lot of good and bad effects of that. And from the perspective of a prosecutor, when we are working, we are helping, we are putting evidence on behalf of the state to come with the truth, and so that the justice can prevail. In that perspective, our thinking is the welfare of the society. So maximization of profit by corporatizations of the things, and new things in coming up every day, without that being regularly and thoroughly tested, they're coming into the world only to only to have the profits and all. I don't say that they're always bad. There's a lot of good things. The life has become very convenient. We're now getting speed. We're now getting everything. But there are huge fallacies. There are huge problems arising out of those things. And the biggest problem that the justice system is facing today is how to interpret, how to admit. Because you see, from the perspective of a lawyer, or a perspective of a person who is working on electronic evidence and recovering and recovering the digital evidence and presenting that evidence into the court, we have three very important steps which should be always in the minds of a law enforcement agency officers or a person who is investigating a case. That is collection of evidence, preservation of evidence, and presentation of the evidence before the court of law. So now, first, court of law or any kind of forum. So the first point is how to collect the evidence. Now, in collecting the evidence, especially the electronic evidence, 2 points has to be kept in mind. 2 points have to be kept in mind. One is that evidence has to be relevant, and the second is the evidence has to be admissible. So in working on digital evidence, or now say it's been amended to electronic evidence, when the collection period is very crucial, then the preservation period is also crucial, and ultimately presenting the same before the court of the law. The difference between the non-electronic evidence and the electronic evidence basically is that electronic evidence, as the expert says, in throughout the world, in different journals and studies and all, and we also understand this thing in everyday work, that electronic evidence is very sensitive. It is prone to change, and it's easily to be changed, easily to be altered, and that is why a pre-planned, well-drafted policy has to be executed, and in implementing that policy, every caution has to be taken. Every caution has to be taken to see that the electronic evidence is not contaminated or polluted or corrupted or altered or edited or destroyed in any stage of this recovery of evidence, say collection of the evidence, preservation of the evidence, and presentation of the evidence before the court of the law. So that's why a very important concept is coming throughout the world in technological perspective, especially for the cyber forensic experts and other, and that is a chain of custody. The simple meaning of the word chain of custody is the roadmap of the evidence. Say, for example, if this mobile phone is being seized in connection with any case, so this mobile is nothing but a hardware, a device. Its importance actually starts from the data which it stores within its storage system. So when this mobile is being seized, the goal is also the seizing of the data. But what is happening in India? In India, we don't have that developed infrastructure like the other developed countries. So what our officers are doing, they're making a seizure of the mobile phone. Probably when they're making seizure of this mobile phone, they're going to provide me a seizure list with respect to the identity number, means IMEI number of this mobile phone, and hand over a copy of the seizure list to me. So the time this mobile been seized, the data within is, no seizure is being made with respect to the data within it. That's the big problem. Because what is happening in the developed countries, when they are making a seizure of a device, they are also making a seizure of the data. How that can be possible? basic thing is that the time the mobile is being seized, the data within it is also to be forensically cloned or forensically imaged or forensically copied into a newly purchased sterile device where no computer contaminants are sitting previously. So the rule is that the procedure which should be maintained at the time of seizure of this mobile phone is that to make a before making a seizure of this mobile phone, we have to this is the standard procedure. It's a preferable procedure that to clone the data or image the data in a newly purchased device, and then make a seizure. And when these cloning been made, hash value will be created, because there are a lot of softwares available which can clone the data, and every software has its own algorithm, and depending on these algorithms and the hash value is different. Popularly MD5 or SHA, this type of softwares are being used, forensic softwares are being used to clone the data. So when this mobile is being seized, we are actually making a seizure of the mobile as well as the data. And when this has been happened, then when the seizure is being made, the hash value which has been created automatically at the time of the cloning of the data within it, that has to be mentioned in the seizure list of that mobile phone, or the seizure of that mobile phone. The result will be very simple. The time the hash has been created, the time this device has been cloned into a newly purchased device, the hash is created, and for a particular hash, data is identified. And if there is a little bit of the slightest change taken place in the actual data, the entire hash will be changed. That will going to assure us the integrity of the data, whether the data is being altered in the process throughout the, or in the journey throughout the of the electronic evidence throughout the entire stage, from collections, preservation, and presentation before the court of law. So what we are doing merely when making a seizure of a device is nothing. We have to make a clone of the same, and also and mention the details of the data, details of the device, as well as the clone of hash value, so that the data and when the hash value is being written in the seizure list with respect to the say for example this mobile phone, the IMEI number and other, for a computer there's a MAC, and a lot of identifiable things are there, then the process is somehow now secure. So the first golden rule of cyber forensics is that no one can have the authority to do anything on the original device, and that is why the procedure of seizure or making a forensic clone question I've already discussed about. Now, the first step, no one has the authority to do anything on the original, so we have to make a clone of the same, and every investigation will be conducted on that clone data. And this is also happening in case when we are sending a mobile phone after or a device after making a seizure of the same to the forensic experts, standard forensic experts. They are following their SOP or protocol, and the first step, what they are doing, they are making an image of the same, and thereafter they are experimenting on the image. So the first golden rule is that no one have the authority to do anything on the original. That is one of the basic safeguards which the investigating agencies or the law enforcement agency or the person who is dealing with electronic evidence should take care of. The second step, that every step has to be documented, and they are from the concept of digital, this roadmap of the electronic evidence, how it travels, this comes into play. So the roadmap of the electronic evidence or the chain of custody, that every step has to be documented, and there has because for a case to be proved in a criminal case or like this, a prosecutor has a huge role or burden to prove a case beyond reasonable doubt in applying section 101 to 103 of Indian Evidence Act. So in order to exercise that burden or do the needful to prove a case beyond reasonable doubt, every prosecutor has to make or assure that in dealing this, every investigating agency and every prosecuting agent has to make this point, assure this point, that in the process of or when the electronic evidence travel from the one point to another, they are not tilted, they are not altered, they are not edited, they are not modified, and they are not changed, or no changes taken place into that. If that been so, that the electronic evidence, the value of the electronic evidence is the electronic evidence is of no value, because it is not the electronic evidence which is most important. It is how we collect, how we present, how we preserve, and how we present before the court of law. Now I'll come to a very interesting case recently happened in Bengal. I think if you follow the newspaper, a few days earlier, few weeks, I think on 22nd of March, the judgment came in, and it was widely reported in different medias and other. Very interesting case as well. In 2000, the case pertains to relates to cyber crime in the year 2011. A student, lady student, filed a complaint that when she was conducting law from a national law university, and when she came back in her puja holidays in her house in West Bengal, she was shocked to see that a Facebook account was created on her name, impersonating her, and a lot of lascivious materials and different identifiable informations are being posted into that Facebook account, and repeatedly friend requests been sent to different male member in the Facebook account, and they are being invited by different lesbians, obscene speech, different other pictures, morphing the face of the girl, and all this nasty thing was actually continuously happening. And this was went on for more than 1 year. When the lady first time saw the fake account, she intimated the same to her father, and her father filed a complaint before before one of the PS in West Bengal, and then CID West Bengal took up the case. And I'm going to show you, see how this traceability path, how this concept is getting popularity in throughout the world. When I first took up the charge as a prosecutor in the year 2013 and 14, I tried myself to come with this traceability path in different cases. And I think nowadays even the higher courts are actually approving the application of the same, because if you go by the basic definition of evidence as per the Indian Evidence Act, that is for documentary evidence, anything placed before the court for inspection is an evidence which includes an electronic records or document. So evidence can be anything. We only have to be careful about whether the evidence is admissible and whether the evidence is relevant to the fact or incident or what you want to prove. Now, in proving the same, nowadays you understand that a huge amount of people, so India is the second largest internet user almost. So huge number of Indians are every day using the internet and computers and different account type of application, mobile applications. They're flooding in the Play Stores. So if you want to collect evidence and to build up the very chain of circumstantial evidence, you'll see that you're going to get data or evidences in the mobile phone of the offender, in the mobile phone of the victim, in the mobile phone of the witnesses. So these are actually evidence which we can come with before the court of law, and which can prove the motive, the conduct, the very circumstances, why somebody is being killed, why some untoward incident already happened, why what is the motive behind the incident and all. Recently, you see there was a murder case in where a lady was convicted for allegations of murdering her own husband, and in that case also a lot of electronic evidences has been applied in proving the motive, conduct, and different things. Say for example, the WhatsApp chat, the Facebook post, the Google history, all these type of evidences. I have come with that case in dealing with my duty as a special public prosecutor. So I was just discussing about this 22nd March judgment, and that's also available in the internet. You can go and read that judgment as well. So what happened that when investigation was started, we have now. I'm going to share my screen. I'm going to show you the basic sum of the step which the investigating agency has actually adopted in that time. So let me. You know that when I am connected with the internet, I'm always having. I have been allocated with an IP address. So this is my mobile phone. So if I click on the mobile data, you can also click on your mobile data. You see your mobile phone is then connected with the internet. So the time you click on the mobile data or the Wi-Fi data, which is you want to be connected with the, and you are connected with the internet. The very time when you are connected with the internet, your internet service provider is providing you with an IP address, allocating you with an IP address. And if you go by, I'll come to the very interesting topic, that is local exchange principle. You see that a very age-old, decade-old concept that every criminal, every person leaves a trace in the PO or in the system. That is also equally applicable and relevant in case of different type of cybercrime cases. Also, you see the same applications here. So what is our case? A lady filed a complaint, or sorry, her father filed a complaint that on her daughter fake Facebook account was created, and the lady as a witness provided the URL of that Facebook account. So 2 or 3 points is very important. I think you all aware of the fact. So need not to repeat the same. So every URL is actually representing a particular website or a page, and that's one of the things we are using in the judiciary, in the legal system, to define a page, because every time you put that URL into the system, you will get that same page being open. So every time we are in the system, we are allocated with an IP address. So we can check. You can check your own IP address by typing what is my IP, and you will get your IP. This is my IP. So this IP has been copied, and there's another very simple free resource, which is you can go and say for example, that every IP has been allocated by an internet service provider. You all know that. So in case when the IP is traced of the offender, then definitely that IP is also been allocated by an his or her internet service provider. So if we can reach to the internet service provider of the offender, then we can ask the offender whom you have allocated that IP on that very date and time. So this is a very basic point of the traceability. I'll try to show you one by one. And same mechanism was applied in the case where conviction was awarded, and 1.5 lakh rupees compensation also awarded in this case. So in this case, what happened? I told you a fake Facebook account was created. So the investigating agency got the URL and put that URL into the IP lookup. So this is IP lookup. So investigating agency got the URL, and in the URL, if you open the URL, you see there is an YouTube. If you want YouTube, I have my own YouTube. I will welcome you all to come to my YouTube and visit and if you watch. There are all videos connected to or related to this subject, and there are some. So you go to the. Sorry. So you go to the YouTube and write Vibhas Chatterjee. So this is my YouTube channel. So in this channel, I have some of the basic videos on electronic evidence and cyber law and other. You can go and watch. But what I want to show you, when I open my channel, there is a URL. So this is an URL. So you can copy this URL, and then you can, if you want, you can
So,
put it.
sir,
Yes.
may I interrupt? Sir,
Any problem?
yes, sir. We cannot see the YouTube channel. We are just seeing your Explorer, Windows Explorer. I
Okay.
think you'll have to share your screen.
I have already shared my screen. Give me 1 minute of time.
Sure, sir.
Is it okay? Is it okay? Hello.
Yes, sir. We can see the poster, and so you can now turn your YouTube channel on. We can just confirm.
Is it okay? Hello.
Not yet.
Uh, you can watch my YouTube account. My
No, sir.
No, sir. No, sir.
let me check. So, is it okay?
Yes. Now it's okay, sir.
Okay. So you can see that this is one of the channel, and the only purpose of showing this channel is obviously to collect this URL. So if you pick up this URL, and I just open a Word file, say new Word file, and I can put this into here. So this is the URL, and I want to make it a bigger size. So you can understand this is the
Sir,
URL.
Word file is not visible.
Okay, I got the point. Sorry.
Application to that.
Anyway, so this is, I think, okay now. So this is an URL.
Yes, yes.
And within this URL, you see there are 3 parts. One is the protocol part, another is the domain part. This is the domain part, and this is the path. So in order to define an URL, we get 3 paths, and for investigation purpose, this domain part is very important. So our case is that a lady visits a PS and file a complaint that a fake Facebook account was created on her name, and investigating agency had to investigate the case. So think about this. This is Facebook. So in this case, the step number 1, obviously, in case of traceability path, the step number 1 is the collection of URL. So collection of, I already discussed about uniform resource locator. So for every page will be going to be defined by a particular URL. You see that my URL page, my Facebook channel was also defined with an URL. So for a Facebook account who has the allegations, also have an URL for the fake account. So collection of URL is basically you can do, because the URL is an electronic resource. It cannot be touched or taken in such a way that we are taking some container and other thing. What we have to do, we can do this way. There are so many ways as well. So we can take a screenshot from the victim containing the all the pages containing the URL on the top of the same, and that can be seized from that lady. And as per the Arjun Pandit, the latest judgment on electronic evidence, it says, see, there was very huge conflict between throughout in India, and the reason of the conflict I'll come to because of the section 65A of Indian Evidence Act, because it says the content of an electronic record may be as provided in 65B. So the maybe concept is actually been interpreted in different time differently. In Parliament at a case, it was interpreted that non-compliance of 65B along with an electronic evidence is not fatal. After 9 years in 2014, we got the Basir judgment where the Honorable Supreme Court says that 65B compliance. You know what is 65B? It's a statement given by the person under whose custody and dominion the device is, from the device from which the electronic evidence is being produced. Electronic evidence can be in a paper printout. It can be in a device. So it can be in any format. And if you read the 65B subsection 1, you see that instead of the device, we can come with these electronic evidences before the court of law, and we have to, in that case, we have to comply some procedure or cautions, and one of them is to produce the statement under section 65B of Indian Evidence Act. So in Parliament Act case, the Supreme Court says 65B statement is a mandatory precondition, and without 65B electronic evidence is inadmissible. After the few years, in the year 2018, in Safi Mohammed case, the Honorable Supreme Court says, no, if the evidence is otherwise relevant or important or can be relied upon, it is not that only lack of 65B, the evidence has to be thrown away into dustbin. And going one step further, the Honorable Supreme Court says, if we do not have the device with us, then we don't have the compulsion to provide the statement under section 65B. So, so you can see that the Basir, the contention of the Basir and the contention of the observation of the Safi was just reverse, and that is why both the judgment was placed to the higher bench for a clarifications, and that clarifications comes in the Arjun Pandit Rao judgment, and the very beautifully explained concept in Arjun Pandit Rao judgment can be summarized in very simple 3 points. One, that if the persons coming with the device which first captured the data, then we can think that this is the original data within it. And if that is coming, there is no requirement for giving statement under section 65B of Indian Evidence Act. Simply give an example. Say, for example, I was going through a cab in a road, and all of a sudden I saw something happen in the road. I pick up my mobile phone and capture the video of the entire incident, and that was first time captured in my device, and that is why that can be taken, that can be done, though technically it is impossible to think anything original in the electronic evidence parlance. But herein we are thinking that this evidence is the original evidence, and if the device is being collected by the investigating agency, then there is no requirement of a statement under 65B to be given by me when I'm giving this mobile phone to the investigating agency. Now comes the next point.
Sir, sorry to
Yes.
interrupt you, sir. The screen is stuck on the Word application.
I know, but
Okay,
you can.
thank you, sir.
I'll come into that. Then, how long the class is? I think 11:30, na? Hello.
Yes, sir. You can continue till 11:30 if it's not a problem for you.
Okay.
Thank you, sir.
So the next point that in Arjun Pandit judgment says that if there is practical impossibility or inconvenience that I cannot come with the data first time captured or original evidence, then we have to provide statement under section 65B of Indian Evidence Act. So see, in our present case, the lady visited the PS which comes in screenshot, and those screenshots are basically nothing but the data collected from the space allocated in the server of the Facebook for us to conduct our Facebook account, and we can open into that Facebook account using our ID and password. So that perspective, that data, we cannot come with the original server of the from the California or other place of the world, the original server of the Facebook. So Facebook Incorporation. So what we have to do, we have to come with a screenshot of the same. In that case, the lady has to give a statement under section 65B of Indian Evidence Act, because she was giving this evidence from using where the screenshot was taken or the data was downloaded using her mobile computer, which was kept by her under her dominion and control throughout the time. So the lady will going to file a statement under section 65. There are a lot of formats. You can go to even you can come to this so you can come to my own blog, that is Cyber Chatterjee. So you can open, you can come here and you can read a lot of articles. One of the articles is how to write statement under section 65B. I have given 3 easily copyable or easily followed format of 65B statement, one for WhatsApp evidence, one for Facebook account evidence, one for Gmail evidences. This is a simple example. It can be changed in case to case situation to situation. So you can go and read the blog post, and one of the posts is very popular, and that is writing and drafting statement under section 65B of Indian Evidence Act. So that is one point. So in our case, actually, what I was actually discussing, that the first step was collection of URL. So when we collect the URL, you understand that the URL will be collected, making Caesar of the page which contains the URL. Now the second step is inspection of the URL and taking necessary action. So how can we inspect the? I already discussed about the URL, and the domain part is very important. So our job will be to, in the second part, will be to firstly inspect that this URL was allocated by or originates from Facebook or relates to Facebook or addressing to Facebook, and this Facebook account. Then the second step is to write letter to Facebook authority with a question that a lady filed a complaint, and this is the definitely cognizable case FIR registered, and this is the URL, and with respect to you and mentioning the URL, the investigating agency will go to ask three questions. Question number one, two questions. First question is the creation details. You understand what is creation details? Everybody creates a Facebook account when with the help of a mobile phone or an email. It may be Gmail or anything. So that creation details, if you've been asked, then the Facebook authority, with respect to the URL or the account of this URL, will going to provide. Say, for example, if this is this. Sorry. So with respect to this, they can provide with the details of the how it was created and all. And then the next point is login details. So in case of login details, login details. So login details is basically we have to provide a date and time, because the lady files a complaint that a fake Facebook account created, and on yesterday at about say for 7 p.m. Lesbia's picture was posted. So if you're going to ask login details, they investigate, the Facebook will going to provide you the huge data every time you logged into the Facebook. So in managing those entire data is very cumbersome. So from that perspective, we can make zero down the investigations or make the investigation manageable. We can ask the login details with respect to a date and time. So with respect to our date and time, so a particular date, we can give the date of yesterday and time, say for example 7 p.m. That is going to give a perfectly few number of IP addresses. That means yesterday at about 7 p.m. when that lesbia's post was made on that Facebook account, somebody entered into that Facebook account, and then when he has entered into the Facebook account, he was carrying of IP address with respect to date and time, and the log of the Facebook actually captured that IP address with respect to date and time, and we are asking the same from the Facebook account. This is very simple. Now come to step number 3. Say for example, in step number 3, think that the Facebook, you ask the Facebook the creation details and login details, right? And the Facebook has provided you with the IP address and details of the mobile number and all. You can ask the mobile CAF from the service provider, and here you can get, if this taken in the right name, you can get the name and details of whose number it is, who has actually registered the Facebook account from that mobile phone and committing the crime. So for login details, we're going to get some log which has been recorded in the Facebook server, and those logs or log, actually the log, this IP address, we will put it there. This IP address I already showed you that you can go to the browser and type IP lookup, and now come to, I'm going to show you this thing. Sorry. So I can put this IP log, sorry, IP lookup. So if we put the IP lookup, you see that a lot of pages been opened. There are a lot of pages open. You can open any page you want. So one of my favorite is IP locations. So you on opening, you'll get a lot of things. You can put any IP here. I already have an IP, default IP of my system, and I can put this IP into this box. So I can also put this IP as well. So if I put this IP into this box, after I'm clicking on the IP lookup, after a few minutes, if I scroll down, you see this is the IP, and this IP was allocated by one internet service provider. So I got the details of the ISP with respect to IP. That actually I have checked, and then you can understand that we can go to our Word file. So in after putting this IP lookup, I can put the IP into it, and if I click, I'll get the ISP. So from this, I'll get the IP lookup. I put the IP addresses, and then I'm going to get the internet service provider company name. So the last step is very simple. We're going to ask the ISP, or going to write a letter to the ISP, to the ISP. We're going to write a letter and ask them for giving a table. The table will contain the date, the time, and the IP we already obtained from the Facebook authority. So giving this table, we would ask IP allocation, or IPDR, or IP log. So you can understand, thing very simple. First, we're going to collect the URL. I'm just showing the procedure followed by in different perspectives. First, the IP, the URL is collected. Then with respect to URL, we're going to ask the domain name company whom you have provide the details of the IP. They will going to provide the IP which is captured in their log, and we'll get the IP, and we will put that IP into the IP lookup. We'll get the name of the internet service provider, and from the internet service provider, we're going to ask the internet service provider whom you have provided this IP on that day, on that very moment. So that's it. We get the details of the, and get the log, and in the log there will be the mobile number, connection number, there will be the IMEI number, there will be cell ID which can be decoded to get the location of the offender, nearest tower location of the offender. If it is on the go, then you can collect the LBS, location based service, which can specify exactly the device within 50 to 100 meters specifications. So we can reach towards the house of the offenders. So come to our case, which I was actually I was discussing with you, that 22nd March Judgment Wala case. So that in that case, what happened? The lady files a complaint to her father, and investigating agency with the URL requested the Facebook to provide the IP address. Facebook provides the IP address. IP address was put into the IP lookup. It was seen that it was given by the BSNL broadband. That time the Calcutta telephones was requested to provide the IP log or IP allocation details. They provided the same, and in that there was a specific name to whom this broadband connection was allocated. The investigating agency make a raid of the house, collected the hard disks, and the hard disk was sent to the forensics CFSL, Central Forensic Science Laboratory. Central Forensic Science Library, when it was sent, some question was asked with respect to the suspect hard disks, and in that investigating agency, the forensic lab got some evidences, and they provided the same. When I took up this case in the year 2016 at the flag, and in the month of, I think in the month of November or so, I started, when I entered into the case, I saw that 3 witnesses already been examined. So I was appointed as a special PP on behalf of the CID as a second special PP into this case instead of the first, in place of the first one. So after entering into the case, It was a very age-old case. The case started in the year 2011. I was into the first end of 2017. The first job I have done, that I was not going to the record. I was not satisfied the queries being made by the CID with respect to the suspect devices. What I have done, I have temporarily halt after stopping or adjourning the entire procedures of evidence taking another. I place some pages, exactly human readable pages, the obscene picture, the mod picture of the lady, the lascivious post and everything. Specifically 5 posts I pick up, and I pray before the learned court that I want to make a re-examination of the forensic device whose clone already been captured and recorded into the before the forensic experts office. So I made a PR under section 91 CRPC, and these data, the sample data with respect to that hard disk was again sent, and the investigating agency working on those things on my PR for further examinations went through that hard disk, and out of the 5 deleted pages, 4 pages could be recovered, and that actually turned around the entire case. It was a turning point for the entire case, because the relevant pages with respect to the case is actually been found in the hard disk of the offender. And not only that, that chat history, because if you are owner of a Facebook account, then only you can chat with the help of your from your Facebook account with the others using your password and ID. No one who has the password can do it, and that is one of the sure point of that. For in his hard disk, in the offender's hard disk, the crime was been committed and has been continued to be committed. So this was actually happened, and ultimately putting all these electronic evidences, a lot of judgments and a lot of other different type of facts and all, lot of actually basically love to have experiment, because it's a very new field, and in this area experimental attitude is very much required, because I again telling that electronic evidence, lot of new things is coming up every day. And you see there's a lot of, even you go to the judicial system, you see different interpretations coming with respect to different time and date. And take only the interpretations of section 65A, the clause, the phrase maybe. So this is actually our thing. Just to conclude my today's speech, I'll definitely come with a very interesting point, actually, which I always prefer to have, and that is potentially limitless applications of the computer technology to the evidentiary question will continually require our this is a fantastic observations in Penny versus Commonwealth case. Potentially limitless application of the computer technology to evidentiary questions will continually require legal adaptations. So we are in the process of changing, we are in the process of experimentations, we are in the process of adaptations, we are in the process of we should have an open mind, because after the section 4 of Information Technology Act, you know, our basic cyber law is Information Technology Act. It has been amended to 2017 till the Finance Act, and I'll definitely invite you to come and visit to my mobile application, because in the last pandemic period when I was sitting in my house, I made some mobile applications. Some of the applications relevant to today's class. I have a mobile application in the name of Electronic Evidence. You can install that mobile evidence. It's a free app, and I myself have coded that same in the Android Studio with the help of Java, because Kotlin I don't prefer also. Presently I'm working on Flutter because it's fantastic. I'm getting not so much of time because my hefty schedule, I have to make a journey of 200 and 300 kilometer per day, entire West Bengal and a different part of West Bengal. So every time who are watching my or attending today's seminar and other, I'll tell you that everything is okay, but a little bit of preference, a little bit of curiosity towards the technology, especially those who are young mind, I should say, please at least do 1 hour coding a week, because that will going to forget about you are not going to be a computer engineer. But the important thing is your mind will be so much of analytical. You can understand the way things going to happen. In the year 2018, I have completed my certifications in big data analytics, bitcoins, and others. I hardly have application to these cases. Recently, in the year 2019, one of the court learned court in West Bengal appointed me as an amicus curiae, as a friend of the court, and I was called for an interpretations. There was a case. There's a violations of speed limit by a car, and the owner of the car said that I was running below 60, and the prosecution agency is telling no, he has crossed the limit of 60 km per hour, and a case was started. The man contested the case, and it went to the 313 and evidence part and then argument stage, and I was called for, and you see that speedometer, which is actually collecting or recording the speed of the car with the help of the speed of applying the speed of light, because if the speed of the light, the time traveled by the speed of the light within this time is very negligible, and a light is emitted, reflected from the car and coming in, and the speedometer is catching, and thereby they're making a calculating the speed of the car, and every time the input is that it's below 60, it's not reaching 60, the program is running like a loop and all, and when when the input becomes 60 or upper, the program stops and a printout is coming up of the car, and a case has been started. So in these algorithm of the software, this mechanism of the software, there can be bugs, and if there is a bugs, there can be wrong result. And if there can be wrong result, the entire prosecution can be vitiated. So that's the challenge of algorithmic thinking, algorithmic analysis of the evidence. We're definitely going to have in our days, maybe after 10 years or 20 years, when AI will completely going to rule over the world. And definitely not to forget about the quantum computing, which is actually we're going to make the entire world in such a way that the people, the cyber forensic experts, who are the people working on the cyber security world, they are actually put their alarm on, because with the advent of the quantum computing, this entire and the most important cybersecurity procedure, that is the encryption, or this encrypted data can easily be decrypted, which is not nowadays possible by our classical computer, but it can easily be done with the help of that quantum computing. So we are reaching so fast, but I don't think the law is reaching on that so fast mode, and that is the question of adaptability. You're going to find in this Penny versus Commonwealth judgment, there are a lot of adaptations. The motive, the way, the perspective is changing every day. We have to change it with respect to time. Thank you.
Thank you. Thank you, sir. Thank you for your wonderful presentation. We have come to the end of the first session. And sir, as a matter of caution, can you suggest some ways? Suggest some ways for us to be cautious.
Okay. So from the perspective of a common man, to be a little bit, I don't think everything will be secure. Nothing is unhackable. Every system is hackable, as far as my little bit of conception, my knowledge is concerned, with regard to my knowledge. But what I want to say is that every time the most important thing, the device you using, because say 93% devices which is connected into the internet are actually wireless device, and most of them are actually mobile phone. So in that respective mobile or like this gadget, you have to make secure that you are not clicking on any unknown link, because the time I can send you a link, it looks like I am sending a Facebook friend request to you, but it's actually not. When you click it into, some malware or computer contaminant will enter into your system. The most important thing to make you have a very secure, cyber secure world is to pick and choose when you are installing your mobile app. Because when you are installing a mobile app, be careful what kind of personally identifiable information they are taking from you. If they are taking those informations, the Google has identified 256 type of personally identifiable informations, and if that is not required by, then never install that mobile application into your mobile. Always prefer to have a very soft and secure and regularly providing updations or updating antivirus in your computer. It's required, and never, I think, prefer to go any sites which starts with the HTTP. Only start with those sites which has got a SSL certificates, at least starting with the HTTPS. And definitely keep in mind that no bank in the world will call you over phone and ask OTP from you. It's a very common and age-old thing. We call it phishing, one type of phishing. And this phishing is actually taking new strategies, new ways. And I must say one thing: if in this virtual world, in case of financial activities, if we become non-virtual, that is more secure. If we go to directly to the bank and call to the persons previously I am acquainted with, and take that secure and confidential help, in case of at least I'll tell you about the banking or financial sector. Otherwise, the hard-earned money, every day I got thousands of allegations of different part of Bengal in India that money has been duped, the money has been siphoned, money has been cheated, and this is actually happening in senior citizenship, citizen sectors, not in India alone, even in the developed countries. The sector of the victims, most are actually senior citizens. So I will prefer telling you that you not let your fathers or parents who are not very much acquainted with the system to do any kind of online banking, internet banking, and other. And if they are allowed to do, perhaps they have a little bit of knowledge and conception that there are billions and billions and hackers and criminals are sitting in this virtual world, and the biggest crime in the virtual is the identity theft, or I should say biggest phenomena in the virtual world is the identity crisis. What you see, what you feel, what you observe is not the actual thing in the actual world. So there is a hell and heaven difference between the virtual world and the actual world. And that is why I'll obviously definitely tell you that go and have and read the case studies. If you go to internet and search with the revenge porn, the lady watching my program and all, you go to the internet and go to my famous revenge porn case. There's the first convictions by CID West Bengal, case investigated by CID West Bengal. You see how this virtual identity of a lady can be attacked, and that new concept coming in. My argument was from the beginning in that case that a lady can even be virtually raped, and that concept was actually accepted first time in a world judiciary by an Indian court sitting in Midnapur and in West Bengal. So there are a lot of case studies. You go and have those things, you will understand the horror of cybercrime. There are, I'm again repeating, billions and billions of criminals are sitting to dupe you, to defraud you, to cheat you. All you have to do, you have to have a very secure, you have to put your mind first, then go for anything. There are people who are going to make social engineering on you. They are going to make a situation. They are going to make you so illusionized that you'll be prompted to do what they're telling. So don't fall prey into their trick, their trap, and their plot. And I prefer to say, when you are sharing some data, be careful where you are sharing. Don't believe everything, every link, every URL, everything, unless and until you know that. Don't accept the friend request with whom you have no prior physical acquaintance, means you know him previously on the physical world and all. And definitely there are organized crime in these friend-making sectors. There are people coming from Nigeria. Yes, the days are gone that the criminals were sitting in Nigeria and cheating the people in India. Now the Nigerians are coming into India. They some of them have their passport and visas been expired. They are making, even in going in the matrimonial side, they are having some profile in the name of a famous doctor or a lawyer or an engineer in that profile. They're actually basically of the cheater, and they're befriending with the ladies, and even they're going up to the level of the proposal of marriage and all. Then they have been cheated. There are a lot of cases are there, at least in my hand as well. The trial is going on. So from that perspective, I'll tell you that in this virtual world, you use it to the beneficial part. You go to the WikiLeaks, you go to collect the resources and everything, but never fall prey with this or come into the trap of all these fraudulent people who are sitting. The numbers is huge because
Thank
it is
you,
soft
sir.
money.
Thank you,
Thank
sir.
you.
Thank you very much, sir, for your presentation. We have come to the end of the first session. Now I hand over to Professor Shantanu Shur.
Shantanu, you need to unmute yourself.
Good morning, everyone, and thank you, Professor Rinita Das. The permission of our principal, Reverend Dr. Dominic Savio, I start the second session of our day. This pandemic time has taken all of us to the virtual world, and we spend a lot of time in the online world. Alongside, there has been a steep rise in the cybercrime cases. Cybercrime can be committed single-handedly by a person and does not require any physical presence of anyone. Thus, it is easy to commit and very easy to get victimized. We need to be vigilant and aware about the precautions to be taken while being online. Keeping this in mind, we start our next session on the law relating to cybercrime in India. We now have with us Dr. Anirban Majumdar, Associate Professor of National University of Juridical Sciences, Kolkata. Dr. Majumdar, a graduate from Calcutta University, has done his LLB from Burdwan University. He went on to do his LLM from National Law School of India University, Bangalore, and MPhil from National University of Juridical Sciences, Calcutta. He has been awarded PhD by National University of Juridical Sciences, Calcutta. He specializes on intellectual property law and information technology law and offers these subjects both in undergraduate and postgraduate level. He is associated with institutes and universities in Munich, New York, Cardiff, and Israel. His publications include contemporary topics like legal implications of electronic commerce, anti-cybercrime legislation, and anomalies in copyright law. Sir, it is an honor to have you with us today. I request you to take over the session.
Good morning, everyone. Can you hear me?
Yes, sir.
Yes, sir. Sure.
So, thank you for those kind words, and let me. Can you see the
Yes, sir.
presentation? Now, as you are listening to Mr. Chatterjee about the case studies relating to information technology and cybercrime and its investigation, if we go back to the basics, then this is how we are interconnected. This is a virtual, symbolic network connectivity which we have around us, and because of which we can interact with each other today, although we are sitting in a different location. And that's the main source of all IT or information communication technology related activity. At the same time, the cybercrime is also because of that. Now, this is the notification which was referred by Mr. Chatterjee, that that the cybercrime has gone to the extent that people are even using matrimonial websites to conduct these crimes. And this is the notification from Ministry of Communication and Information Technology, we are addressed to all matrimonial websites who are operating in India, and what are the to be done and what is not to be done. So to do and not to do list has been given to matrimonial websites, which indicates that it's not only financial matter related crime or obscenity related crime. It can even get into any field, wherever you are working or wherever you are interested, and cybercrime can operate from there. Parallelly, if we look at this document, this is written by John Perry Barlow in 1996, and this is called, the title is Declaration of the Independence of Cyberspace. So John Perry Barlow's observation was that.
Sir, if I may interfere.
Yeah, please.
Sir, are you showing any PPT? You need to share your screen.
I have shared, I believe, isn't it? I asked you that whether it is visible.
Sir, your voice was.
You said yes. Can you see this now?
Yes, sir. Now it is visible.
Okay.
Thank you, sir.
Okay, so let me just go back, because possibly you have missed it. This is the virtual connectivity using which we are interacting today, using which the cyber crimes are conducted, and all the advantages of information and communication technology which we enjoy, all because of this connectivity. This is the reference of that notification issued by Ministry of Communication and Information Technology, and it is directed towards matrimonial websites which are operating in India. This is to indicate that as cyber crimes are taking place even from matrimonial websites, so that's an indication that gone are the days when we are only concerned about finance related crime or crime which are based on obscenity or pornography, but today from any sector cybercrime can originate and operate. So even when you are dealing with a matrimonial website, there is a possibility that you can be victim of cybercrime. So this is a notification from the ministry giving a sort of guideline that what is to be done and what is not to be done by people who are operating as a matrimonial website. With this, example, if we also look at John Perry Barlow's Declaration of Independence of Cyberspace in 1996, Barlow's observation was that actually the cyberspace is an independent space. It's an unique area which is not generally part of our regular territorial operation where government is governing us within the geographical area. So Barlow was of the observation that you have no sovereignty where we gather. That is, the cyberspace is an unique space, and the sovereignty which are enjoyed in the physical world are not extended here. If you also look at the highlighted portion, that you have no moral right to rule us. or do you possess any method of enforcement? That a government which is elected by the people for physical world are not necessarily having any moral right to control what is happening in the cyber world, because for him cyberspace was an unique independent space which is disassociated from the physical world. He is also of the opinion that all may enter without privilege or prejudice accorded by the race, economic power, military force, and the station of birth. So internet is actually a space which is truly democratic, because it does not discriminate on anything. It does not discriminate based on from where you are originating, from where you come from, what is your race, what is the economic power which you have. So everyone is equal in that sense in this digital world. He is also of the opinion that here anyone and anywhere may exercise his or her belief. So this is truly democratic, because whether you are from India or from any other country, if you have an opinion, you can express yourself without any censorship, without any restriction, without any editorial control. And then more importantly, your legal concepts of property, expressions, and identity do not apply to us. So he is of the opinion that that the understanding which we have about property, the understanding which we have about expression, about our identity, they cannot be extended to digital world, because digital world is completely unique, is different, and has nothing to do with the physical world. If we look at the case of Yahoo versus Lycra, here you will find that the High Court in Paris, they observed that Yahoo US, that is Yahoo which is operating from United States, has to take all necessary measures to dissuade and prevent access to auctions for Nazi memorabilia, because you know that these Nazi memorabilia, they have a sentimental issue in France. So although the Yahoo US, which is operating from US, was visible from France, and people from France could participate in these auctions which are relating to Nazi memorabilia, court ordered Yahoo France to warn users that should Yahoo's search result include content prohibited under French law, they shall refrain from accessing such content to avoid incurring legal sanction. That is, if you are visiting those sites, if you are visiting those sites from France, then that can result into a legal action, and that's why they should be warned that this sort of incident should not take place. At the same time, a court ordered Yahoo US that to take away all these material from the accessibility or viewability of France. Now look at the problem. When we talk about internet, we talk about a global network, a global village. So something which is operating in the global level, how can you differentiate that this part of internet is part of France, this part of internet is part of US, and how can you say that, okay, this might be visible from US, but this should not be visible from France? So what you are trying to do is that you are trying to break the global network again into territorial demarcation, and trying to correlate with what is allowed and permissible in your territorial location. So this French people's sentiment regarding Nazi memorabilia, which has to be protected in France, which has absolutely no application in rest of the world, and you are trying to bring that into the internet and suggesting that, look, Yahoo France has to take an action, and Yahoo US also has to support that people from France should not access this material. They may be accessible from other country, but from France they should not be accessible. So that indicates that there is uh, a sort of tension or a conflict between the global understanding of internet, the global structure of internet, and the way law operates, which is very territorial in nature, very local in nature. So there is a conflict between the way architecture of internet operates and the way the legal action operates. So this conflict between territorial law and global technology will create sort of conflict, will create sort of tension, which we have to address at a later point of time. If we also look at Lawrence Lessig's observation, Lawrence Lessig is of the opinion that if at all internet can be regulated, it can be regulated only via technology. He is of the opinion that internet is a product of technology, and any product of technology can be regulated by a superior technology. So for him, that technology in the sense the code, the IP protocol, which is responsible for the operation of internet, are the true regulator of internet. It's not a law enacted by by the parliament or by Congress. Rather, it is the software developers who are constantly working on different type of features which are coming up in the internet, and they are the true regulator in internet. So if you look at the way YouTube operates, now if you try to upload material in YouTube uh, uses a technology which is called content ID based technology, where YouTube tries to match the content which you are trying to upload and the content which they have with their reservoir. And if they find that that is identical, they will not allow you to upload, which is an indication that so that pirated material can be blocked. Now this technological filtering is possible because of a superior technology which is used by YouTube. In the absence of that, it was impossible. So Lessig's observation that this is an example that how internet can be regulated by technology, and only by technology. So your technology of copying has, if there is a superior technology of copying, then that cannot be controlled by a law which will prevent illegal copying. Rather, you have to have a superior technology which will be able to detect this illegal copying. So, you are going to look at more activity or more usefulness of softwares which are going to decide what is to be permitted and what is not to be permitted. So as a licensee, you will be more guided by the terms of the software, by the terms of the software license, rather than what you want to do and what you do not want to do. So your activity will be controlled by the licensing term of the software which you purchase. If you look at the market regulation in the internet, that today if we are taking benefit of all the telecom companies who are having a stiff competition among each other, and they are ultimately giving us the benefit, and we are getting easy accessible internet at the cheapest price because of the competition among the telecom operators. If you look at internet protocols, there are organizations like W3C, which is called World Wide Web Consortium. They constantly operate or work on the on internet protocol better features, which makes the internet more progressive and more dynamic. And these are the people who will be possibly trying to regulate internet, if at all you want to regulate internet. if you look at ICANN is Internet Corporation for Assigned Names and Numbers, who are the organization who allocates domain name. So if you are looking for domain name, you have to approach to ICANN. Now this ICANN till 2005, they were within US government's control. No, it is US government who used to regulate ICANN. So although US, ICANN was a global organization which is supposed to allocate domain name to everyone, but by its origin, it was part of US Department of Commerce and it was under the US government's control. But there was a reaction to that, that why a global agency should be under US control. So it should be actually made a global body which is independent from any of the government regulation. So what happened is that US government because of that, US government pulled out from that from the control of ICANN. Now what has happened is that as a result, there was a fund crunch for ICANN. As a result, there is a sort of relaxation in the regulation. There's some sort of loosening up in the approach, the way they function, and obviously there is an apprehension that in the name of sovereignty and independence of ICANN, whether we have compromised with the efficiency of ICANN or not. So that in future we are going to see whether the ICANN is operating more effectively as it is now an autonomous organization, or it was better performing under the aegis of US government. If you look at the issue of jurisdiction, that becomes always important in cybercrime, because the first question will be asked that whose jurisdiction it was. So if a cybercrime took place in India, then the question will be that whether it is within the jurisdiction of India or it is outside the jurisdiction of India. So jurisdiction is always very important in the functioning of cybercrime. So if you look at IT Act, in IT Act, it very clearly in the section 1, it very clearly says that committed, it applies to offense or contraventions which are committed outside India by any person. So although generally laws are, in the law which we are using in day-to-day life, you will find that the jurisdiction is territorially fixed. So generally it will be written that it will apply to the jurisdiction, to the entire jurisdiction of India or in the territory of India, and it will be applicable to Indian citizen. But if you look at IT Act, it is very clear that it will be applicable to any offense or contraventions which are committed even outside India by any person. That means virtually if an offense is committed in Australia by an US citizen, Indian court can try that as per Indian law. That was the global spirit. That was the global jurisdiction we are thinking of in IT Act. But it has been further narrowed down in section 75, where if you find, it says, the highlighted portion, if you see, that if it involves a computer system or computer network located in India. That means, yes, if an offense is committed in Australia by by a citizen of US, Indian court can try that case, provided in the making of that offense, it involved any computer system or computer network which is located in India. That means it must have gone through an Indian computer system and Indian computer network, which is located in India. That located in India is the is the physical connection which justifies your jurisdiction. So although we started with a global jurisdiction, virtually that you can try any case committed by anywhere, but ultimately it boils down to something which is involving an Indian computer system, and Indian computer network, which is located in India. So that's the justification that why Indian courts should try that, or why Indian law should be applicable to that. Now, if you look at this, situation, then here a pen drive was left on the table. Now, someone who saw that pen drive connected that pen drive to the laptop, found that pen drive is empty, so kept it back on the table. And this entire activity was observed or was recorded in CCTV. Following that CCTV footage, A filed a complaint against B. Now the question is that the pen drive was not taken away, so there was no stealing of pen drive. The only thing which was done is that, out of curiosity possibly, that he took the pen drive, saw the content, found it is empty, and then kept it back. The question is that, is it only immoral, or is it also illegal? Now it is immoral, we all know, because we are not supposed to touch anyone's property without the permission of the owner. Here you not only touched the pen drive, you saw the content of the pen drive. Incidentally, it was empty, but it could have been loaded with material. So you have had an access to a pen drive which was without permission. So it is immoral, there is no doubt about it. The question is whether it is illegal, and if it is illegal, whether it was a civil wrong or it was a crime also. If you look at section 66 of IT Act, which is about computer related offense, and which is very broad in nature, it says that any activity which is listed in 43, if they are done fraudulently or dishonestly, then there will be a crime under section 66, and for which imprisonment, the punishment is imprisonment up to 3 years or fine up to 5 lakhs or both. Now, if you look at section 43, 43 says that it is a penalty and compensation for damages to computer system. Now, when you see this penalty, then you understand that it is 43 is actually about civil wrong. That if you do all the incidences which are referred in 43, then there can be a civil wrong, and you can file a case under section 43 to adjudicating authority, and you can get compensation. So it's not a penal provision in that way. But the activities which are listed in 43, they will be useful for a crime to be committed under section 66, where the first clause, the opening part of it says that if any person without permission of the owner. So if you are doing anything vis-a-vis the pen drive, and if you are doing it without permission of the owner of pen drive, then you might come under 43. And what is that? Access or secure access to any such computer system or computer network. So if you access to a pen drive without permission of the owner, then it's a civil wrong under section 43, and you can get compensation for that. And if the same thing is done fraudulently or dishonestly, then it will become a cyber crime. Now the question is that whether your pen drive is a computer or not. Whether your pen drive is a computer or not, that's the question. Because pen drive is generally, as we know, that it is a storing device. Now, if it is a storing device, then whether you can call a storing device to be a computer. if you look at the definition of computer in IT Act, then you'll find that it's a very broad definition, which includes storing device, not only storing device, it is that the storing device need not to be always connected to the computer. If it is related to computer, then also it is to be treated, or it will be brought under the definition of computer. So pen drive, which is generally a storing device, has been defined as a computer as under the definition of computer. So if you are accessing to a pen drive without permission of the owner, then that's us. And if it is done fraudulently or dishonestly, then it will be treated as cybercrime. Now here I have to mention that when you say fraudulently, means you have an intention to commit fraud. So if it is proved that you had an intention to commit fraud, then it will be treated as fraudulently. So when you saw the pen drive lying on the table and you wanted to see the content of the pen drive, it's not very clear that what was your intention, whether you wanted to defraud or not. So fraudulent intention was not clear from that. Again, if you look at the word dishonestly, in case of dishonestly, you have to have economic loss or economic gain. So there also the question is that economic loss or economic gain. Now, as because the pen drive was empty, neither there was any economic loss, nor there was an economic gain. So even dishonestly is not satisfied. So in all possibility, that incident that you are taking someone's pen drive without permission and looking at the content of it, that might result into a civil wrong for which you can get compensation provided you have suffered any damage. And it will not be civil, cyber crime, because you will not be able to prove fraudulently or dishonestly. If we, if we see that in 2008, when our IT Act was amended, we made an amendment in the definition in section 66, which earlier had the heading of hacking. So hacking is generally unauthorized access, but the history of hacking suggests that it was not always a criminal act. Hackers were not treated as criminal. They were sophisticated people who had superior control over internet, and they had no intention to commit any wrong or wrongful act. Rather, they wanted to check the security system, the vulnerability of the security system, and if they found that your security system is weak, then they used to warn you beforehand. They used to caution you beforehand that, look, you need to upgrade your security system because it is weak. But they were not criminal, and that's why they were respected. Even today, you will find ethical hacking, concept of ethical hacking, where you are not looking at the criminal intent, or you are not looking at an intention to commit a crime, but your concern is to provide a better security system or better security. In that case, that's why hacking has a different history altogether. Although at a later point of time, when people not only got access, they started manipulating with the data, they started destroying, deleting data, then only people felt that hacking has to be criminalized. And that's how, from 2000 to 2008, we had the word hacking within IT Act as a crime. But from 2008, it has been removed. Now we call it to be computer-related crime, which is definitely much broad in its approach. Then if you now this is a sort of image of a cartoon which generally attract younger people, especially children. They get attracted to these images but actually these images might contain computer contaminant or computer virus. So when you download the image, unknowingly you will be downloading malicious code which will target your computer in different way. It might take information out of your computer and pass it on. It might slow down your computer. It might destroy a lot of files from your computer. So it can do a lot of activities, and which you will never get to know till you understand that you have become victim of a malicious code which you yourself have downloaded. So the question will be that for that, if you have to look at how law responds, then when you go to section 43, again in 43 clause C, you will find that anyone here who introduces or cause to be introduced any computer contaminant or computer virus into your so if you introduce a computer in someone else's computer, then it will be and it will give an opportunity to get compensation if you have suffered damage. At the same time, if it is done fraudulently or dishonestly, it will again become a crime under section 66. So just like unauthorized access, even this introduction of computer virus can also be a subject matter of cybercrime. Then the question is about unauthorized download. Now, when you talk about unauthorized download, every day we download a lot of material. The question is that whether all the downloads are authorized download or not. The point is that if you are taking permission before downloading, it's definitely an authorized download. There might also be indirect way of authorization, like say I have made a payment and I have been given permission to download, so I am downloading. It's an authorized download where the authorization has come by conduct. But if I simply download something, how do I read that? Do I consider that as an authorized download or unauthorized download? Now we have to understand this, that there is nothing called authorized until and unless that authorization has been given specifically. There is nothing called implied authorization. The corollary or a crude example can be that if I keep something on my window, I never give permission to anyone to take that from window. Yes, it is within your reach, but you do not have an authorization to take it. So when in the website I keep certain material, those materials are my material. Now, whether they should be in a downloadable format or in not downloadable format is up to me. But just because it has been put in a downloadable format, that does not mean that I have given an implied authorization. And that is where the internet users are divided into two sides. Some people believe that as because they are in downloadable format, so an implied authorization has been given, and that's how internet operates, and you need to respect that. And another side is that there is nothing called implied authorization. Rather, authorization has to be taken specifically. So for example, I might write in the website itself that I do not give permission to download, or you need to ask, or you need to make an user agreement. You should become a subscriber to download, then only I give you permission. So there has to be some sort of evidence that you have authorization, either by becoming a member, or I am becoming a subscriber, or by becoming making a payment. There has to be some mechanism through which you can differentiate yourself from others, that you got permission to download. Otherwise, this download as it is might create a problem, because we do not know whether the download is authorized download or unauthorized download. When you look at section 43 again in clause B, you will find that any unauthorized download can be an issue. You can prove that you have suffered damage, you can get compensation under section 43. And again, if it is done fraudulently or dishonestly, it can become a cyber crime. So even unauthorized download is also taken care of within section 66 and section 43. Now, if you look at the way stolen mobiles are, treated in the society. Now, often you'll find the people, they buy and sell stolen mobile for a cheaper price. The only attraction is that you get a handset which is very for a cheap price. Now, the question is that permissible, or what's the risk? The problem is that these mobiles are available for cheaper price because these are without document. And as they are without document, there is a possibility that those mobiles might be used for the purpose of committing a cyber crime and then destroying the instrument. People might think that you have destroyed all evidences by destroying the mobile, but might not be the case. There might be other circumstantial evidence to pin you down, or there might be other evidences in the network which will identify that you have committed the crime. But again, that's not something which is permissible by the society. So we have a section called section 66B. Now in that section 66B, because of that section, if you are receiving or retaining any stolen computer resource with the knowledge that it is a stolen one, then you will be imprisoned either for a description which is maybe for 3 years or for a fine of 1 lakh or both. So it might be available for a cheaper price, but if knowingly if you retain a stolen computer or stolen mobile, and that itself might be an issue for cybercrime under section 66B. If you look at IPC also has the same provision for stolen property. So the stolen property and stolen computer, they have been treated almost alike, and both of them, the wording of the section you will find are almost the same, barring the difference that one is about the property and another is about computers or mobiles. The point is that if you refer to the term property in IPC, the term property will indicate only movable property under IPC. But if you look at computer resource, which is used in section in IT Act, which will mean that it will means computer system, computer network, more importantly, computer database or software. So even the softwares are treated as a property, as a computer resource under IT Act. So a stolen software or a pirated software can also be treated, can be brought under this section, whereas you cannot bring it under IPC because movable property is only referring to tangible property. So intangible property like software might not fit into that, but that will be very useful if you bring it under IT Act. So it can also, it not only extend to mobile computer, stolen computer or stolen mobile, it can also be extended to stolen software. This is the image which many of you have, are familiar with. This is a cartoon which was forwarded by one of the professor from Jadavpur University, and he was arrested under a section called section 66A, which later on was declared unconstitutional by Supreme Court. But we need to know the law and the consequence of declaring that unconstitutional. Now, about cartoon, there might be two opinions. Some people will believe that they are, example of free speech. They are example of freedom of speech and expression. And some people will think that no, you have, targeted certain political leaders. You made fun of them. So this was as good as a defamation or something like that. If you look at section 66A, which has been declared unconstitutional, there it is punishment for sending offensive messages. And it says that if any person who sends by means of a computer resource or communication device any information which is grossly offensive. So any information which is grossly offensive, but we do not have any criteria that how do you determine whether an information is offensive or not, or whether it is grossly offensive or not. So the cartoon which we have seen just now, whether that is to be treated as grossly offensive or not, there was no criteria. So this law is completely vague in that sense, where it is completely left to the police officer who is dealing with it to read and understand that whether he thinks it to be grossly offensive or not. If he thinks it is grossly offensive, he can go ahead and enforce, and thereby he can always arrest the person and put him behind the bar for a few days till he gets bail. At the same time, those who think that it is not grossly offensive, they might think that look, you are using your power, for some other reason, might be for a political reason. So the question is that the wording of the section was so broad, and as because there was no guideline to it, there is no examples or illustration. So there is absolutely no way to decide that when an information is offensive or when an information will be grossly offensive, and you really do not know. And this vagueness can always lead to a situation where people will be arrested, and that's what we have seen, that those incidences of arrest not only took place in Calcutta, there are similar arrests in Delhi, in Mumbai, in Chennai, and all across the country. There was a concern raised about 66A, and ultimately it was taken to Supreme Court, where its constitutionality was challenged. And in Shreya Singhal versus Union of India, 66A was declared unconstitutional because it was affecting free speech. Because people were hesitant to write something in the internet because they felt that look, there is a possibility that that you really do not know whether it will call for an arrest or not. The problem is that with the declaration that the law was unconstitutional, 66A was unconstitutional, it has not been replaced or substituted by Parliament. So what happened is that an existing law which was declared unconstitutional, thereby it became inoperative. All of a sudden, there was a vacuum because there was no substitution of that from Parliament. So as a result, what has happened is that there are certain issues which could have been addressed through 66A, but at this point of time, we do not have any law vis-a-vis that. If you take this example, now someone was sending mail every day, praising someone's beauty. Now, praising someone's beauty, apparently it looks very innocent and there is nothing wrong in that. But if you start praising someone's beauty every day, at some point of time, it might become irritating and there might be a consequence of that. So what happened is that the person was receiving such mail, all of a sudden filed a complaint and he was arrested. Now, the question is that how do you do that? If you look at 66A, here it says, any electronic mail message for the purpose of causing annoyance. So if you are sending an electronic mail for the purpose of causing annoyance, then that is good enough to create a cause of action on the 66A and you can be arrested. Now the question is that whether it was with the purpose of annoyance causing annoyance, or it was a genuine feeling which was communicated. Who decides that, and how do you deal with such a situation? If you look at these few issues which I have highlighted, like 66A could have been used as anti-spam law. Now we do not, in India, we do not have any anti-spam law. As you know, the spam means unsolicited commercial, communications. So when you start your, when you look at your inbox, it might be full with many mails which are unwanted, which are not, you are not expecting them, neither you have asked for it, but internet has become very easy way of advertisement. And if you can get email ID of 1,000 people, you can reach out to 1,000 people with no cost. So it's a very easy way of advertisement, but at the cost of irritation of the recipient, because recipient inbox might be full with that. So there are many mechanism, like telephone regulatory authority, it has its own policy relating to spam. All network service provider or telecom service providers, they have anti-spam softwares. At the same time, there has to be a law relating to anti-spam. So 66A had the potential to be used as anti-spam law, which we cannot use because it has been declared unconstitutional. Then we do not have an online defamation law. We do have defamation law in IPC, which can take care of both, online defamation as well as defamation in the physical world. But if we are looking for a dedicated, online defamation law, 66A again could have been used for that. But unfortunately, we do not have that possibility. We do not have any law for the purpose of cyberbullying. Now, cyberbullying is something which is happening regularly. We do not have a law, but we could have been used, we could have used 66A for that. There are regular incidences of Nigerian scam, where all the incidences of lottery, in which people nowadays, they have realized that they are simply, to be ignored. But some people still, those who are new to internet, they still, jump on that and then pay some amount of money which will be lost forever. And this Nigerian scam could have been controlled, through 66A. Although obviously they can always be addressed under IPC. Revenge porn, we do no, again for revenge porn, 66A could have been used. We do not have a dedicated law on that, although it can be handled through IPC, but in IT Act we do not have a provision for that. If you look at fake profiles in Facebook, that has become a norm for the day, and that's why nowadays you will find that you have to have a verified account which will stand apart from all fake accounts. For in response to that, we have created a provision called identity theft under section 66C. So if you are using someone else's electronic signature or password fraudulently or dishonestly, then that can be an identity theft. Identity theft was not known in IPC, but in IT Act, in the virtual world, it is the identity which can be stolen. So we are not so much concerned about physical theft, but we are more concerned about identity theft, because identity is something which is which can be stolen at any point of time. So that's why we have a section for identity theft. We have several concerns for job fraud. You must have seen in regular newspaper, where you'll find regular notices or reporting of incidences where there are websites which uh, advertises for jobs which for fraudulent purpose. Innocent people, they make application on the basis of that, and ultimately they lose their money, which are nothing but fraudulent exercise of or use of internet. For that we have a provision of cheating by personation. So cheating by personation, because it is the personation which is so easy in internet, because you are all interacting with machine, and no one knows who is behind the machine. That's why personation is so easy in internet, because everything is anonymous, and cheating can be done so easily. So if anyone who is doing cheating by personation by using computer resource, they can be brought under 66D, which is cheating by personation.
Sir,
The time has
sorry
come.
to interrupt, sir.
Yeah.
We can discuss more and more, but time is restricted. So
Yeah. So no, it will be better if there are certain questions which we can
yes,
take.
sir. We have 2 questions from the participants.
Yeah, please, please.
First question, one of the participants, he has asked, sir, YouTube vloggers, when they are making new videos to make new content, how much is it prone to leak information to the anti-social groups?
Okay. Now, see, it's very difficult to answer until unless we know what is the content of the video which you make. But if we consider that, suppose you are making a video which is maybe you are trying to say, for example, you are trying to record a cooking exercise. Obviously, you have no problem even if it is leaked to any group. But the question is that, suppose in YouTube you are trying to record something which is how to hack website. Suppose I give training how to hack. Now that I put it in the YouTube, and if that goes to wrong hand, then there might be people who will use the knowledge which you have explained, or which you have imparted through that video, and then they might cause certain damage to the society. So yes, it depends on the content which you have generated, and if that goes to the wrong hand, then there might be adverse impact on that. But until and unless there is a report based on that, YouTube might not withdraw it, or take it down automatically, until and unless there is something wrongful, apparently very wrongful material is there.
Thank you, sir. We have one more question. Sir, normally the trained hackers hack data or divert data to the dark web. So,
Yeah.
sir, how much money in our country, how much we are proficient to catch those hackers from the dark web?
See, first of all, no one knows the length and breadth of dark web. Okay, if you look at by statistics, then you can understand that we are not very efficient even for offenses which are happening by using our regular network. Okay, forget about dark web. So I think it is only the tip of the iceberg which you can see. The most of the things are not known. So we should try to enforce our law to the fullest extent, at least whatever is happening by using the regular available network. And dark web, it's too far to address for that right now.
Okay, sir. Thank you for such an enriching session. I'm sure it would be useful to all of us.
Thank you.
And also answering the questions in a lucid way.
Thank you.
Thank you, sir. We now come to the end of the second session. I would request Father Joseph Pulandai, Vice Principal, Department of Commerce, Morning, to deliver the vote of thanks. Father?
Thank you, ma'am. Reverend Dr. Dominic Savio, our principal, respected vice principals, deans, eminent speakers, faculty members, friends, and my dear students, a very good afternoon to all of you. Cybercrime is a criminal activity that can target anyone who is working in the internet world. Cyber criminals can target individuals or organizations. In current times, cybersecurity is of utmost importance. The awareness about the possible cyber attacks and the ways of protection is a necessity. Use of updated software, using good antivirus software, setting strong password for accounts, handling email attachments with care, identification of spam emails, avoid to click on spam links or email attachments are very much essential ways to work in online mode. An online user has to be always vigilant about the website they visit. So today's session has increased this essential level of understanding about cybercrime for all the listeners. In our continuous process of maintaining excellence, such web talk acts as a force to accelerate the learning process with a new dimension. With today's session, we all have been successful in adding one more powerful aspect to our book of knowledge. It is my pleasure to deliver the vote of thanks for today's session. First of all, I would like to express my sincere and heartfelt gratitude to you, Mr. Bivas Chatterjee and Dr. Anibar Mazumdar, for enlightening us on such a relevant topic. I am sure that this has been an effective and enriching session for all the listeners today. I must mention our deep sense of appreciation for your lucid explanations. Today, it was a pleasure having you among us today. We thank you for taking out time from your busy schedule on this Saturday morning to be with us. Thank you so much. I wish to express my gratitude to you, Reverend Dr. Dominic Savio, our principal, for your guidance, unconditional and constant support. Thank you, Father. I also want to thank all the vice principals, Father Peter Arokyam, Father Johnson Padiara, Professor Bertram Da Silva, Dr. Charlotte Simpson for your support and encouragement. I would like to congratulate the Departments of Information Technology, Law and Computer Science for organizing the web talk on such relevant topic of current times. I would like to take this opportunity to place on record our hearty thanks to Dr. Madhu Agnihotri, Head Department of Information Technology, Professor Anita Das, Head Department of Law, and Dr. Romit Bed, Head Department of Computer Science, for conceiving this event and executing it with such finesse. My thanks to all other professors or organizing committee members who worked hard to make this event a success. I want to thank Dr. Amitav Roy, Dean Commerce Morning, and Dr. Sohili Ghosh, Dean Commerce Evening, for supporting us to organize this web talk. I also extend my sincere thanks to all our professors who joined us today and to our students for being such patient listeners. I'm sure we all better informed today. Thank you one and all. May God bless us all.
Thank you, Father. I take this opportunity to thank Father Joseph Ulandai, Vice Principal, Department of Commerce, Morning, for your guidance and greatest support for the smooth organization of this web talk. Now, with the permission of Father Principal, Reverend Dr. Dominic Savio, we conclude this web talk on cybercrime and the law. Participants, kindly fill up the feedback form given in the YouTube link before leaving. On behalf of the whole organizing team of St. Xavier's College, Autonomous, Kolkata, I thank one and all for your sincere participation, making this web talk a success. Thank you all.
Thank you, ma'am.